There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
All right, guys, today we've got another wild court moment to look at. This time, it's someone who violated her probation due to drug use. Instead of going the smart route and asking for a public defender like most people would, she chose to represent herself. And as you can probably guess, that didn't exactly work out well in my opinion. She doesn't really seem like a true sovereign citizen. It feels more like she's just reading from one of those internet scripts, trying to sound like one. But I'm curious to hear your thoughts. Do you think she actually believes in what she's saying? Or is she just repeating something she found online? If you enjoy this kind of content, be sure to like and subscribe. And now, let's dive into the hearing.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
Does anyone else feel even a little bad for her? I mean, yes, she broke the law and clearly made some poor choices. But watching her go through this kind of public embarrassment is honestly uncomfortable. It's one of those moments where you almost want to look away. That said, it's hard to feel too sorry when you realize this could have all been avoided. She had a public defender literally sitting right next to her, ready to help, and she just waved him off. I really don't understand the mindset behind these sovereign citizen beliefs. Choosing to represent yourself when legal help is freely available just doesn't make sense. The attorney looked calm, professional, and ready to assist. He even seemed relaxed, sipping his coffee, just waiting to do his job. And yet, she still refused. What do you think? Do you feel any sympathy for her, or is she just facing the consequences of her own choices? Let me know in the comments. Let's jump back in because she's about to face a serious reality check.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
Stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Cool. So, apparently, this sovereign citizen believes she should be paid $1,200 for every minute she's in jail. Yes, you heard that right. $1,200 per minute. Despite the fact that she violated probation, continued using drugs, and even put her child at risk at first. I almost felt bad for her, but after hearing that claim and seeing her attitude in court, I take it back. When you break the rules and endanger a child, jail is more than fair. On top of that, she made a rude and snarky remark to the judge right before being taken into custody. While it may not have been a direct threat, it was definitely inappropriate. And honestly, I think the judge would have been justified in holding her in contempt right then and there. People like this seem to believe they're above the law just because they reject the court's authority. But that's not how any of this works. There's no reward for ignoring the rules or putting others in danger, and certainly no paycheck for being held accountable. This isn't some heroic stand against injustice. It's just someone facing the consequences of their own actions. Let me know in the comments what you thought of this hearing. Do you think she has any real chance of getting out of this, or is she completely out of options? And be honest, do you think she's actually getting that $1,200 a minute? Yeah, I don't think so either. If you enjoy content like this, be sure to like and subscribe. Thanks for watching, take care, and I'll see you in the next one.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.